live link, so we're just waiting for a few minutes to allow everybody to join before we start.
Right, I think I'll start actually. Good evening, ladies and gentlemen. Welcome to the first ever Court of Protection Bar Association Black and Ethnic Minority Careers Evening. It's very good to see so many of you attending on a Friday evening. I'm sure that you'll find the evening informative. This session is being recorded for your information, so you will be able to view it on our YouTube channel in due course. There is a Q&A box on your screen, so if you've got any questions, do ask them as we go along, but they won't be answered until the end. And there is a special session on pupillage, so if you've got pupillage questions, you might want to ask those after you've heard the pupillage session. Now, my name is Vikram Sachdeva. I'm a QC at 39 Essex Chambers. I studied both medicine and law at university, and I have a wide-ranging practice, including court of protection work, including some quite interesting questions of cases where there's a dispute over life and death, whether the patient should live or die. And I find court of protection work extremely interesting, and I would really commend it to all of you to look at, because I think it can be very fulfilling and worthwhile. Now, we have some very interesting speakers coming up for you. First of all, we've got Aswini Weereratne on the general work of the Court of Protection. After that, we have Nageena Khalique on serious medical treatment. Then Peggy Etiebet is going to talk about welfare, always a good topic. And then Ulele Burnham is going to talk about the crossover between Court of Protection, administrative law, and in particular, I think, mental health. Then Parishil Patel is going to talk about deprivation of liberty safeguards. Ruth Hughes is going to talk about property and affairs, and Turan Hursit is going to speak about pupillage, what you've been waiting for. And then after that, we'll have questions. So without further ado, over to you, Aswini.
Thanks, Vikram. So I'm Aswini Weereratne QC, and I practice from Doughty Street Chambers in Court of Protection and other related areas to do with people who are vulnerable and in need of protection for one reason or another. Tonight, you're hearing from a range of amazing BAME practitioners in the Court of Protection, and I would guarantee you that you wouldn't have this choice of speakers at the commercial bar. But I imagine that you're here because you're not thinking of a career in commercial law. And I'm going to just start with the doom and gloom, just to get it out of the way. The BSB publishes annual statistics about the progress of BAME barristers from pupillage to silk, and the graph is not a pretty one. It comes in at a fairly level playing field and then dips very sharply. Sustaining a practice through to seniority, it has been really tough, I would say. I've often thought of finding myself another career for all sorts of reasons to do with, am I good enough, or do I have the right background, and so on. But I suspect I rather remained through inertia and then ended up, to my own surprise, making it to silk. I cannot say that I had a pre-laid plan for this. I did do a degree in experimental psychology and came to the bar to do mental health work, which of course I have been able to do. But I really do regard myself as being quite lucky in that regard, and I do enjoy my work. I have to say also now, I'm not going to be able to stay for the whole event, but if you want to send me questions separately later on, I'll be more than happy to see if I can answer them, and I hope you enjoy your whole evening with the Court of Protection Bar Association. So you're about to receive some expert presentations on the specific aspects of the Court of Protection, and I'm providing you with a broad overview of the jurisdiction. So in a nutshell, the starting point is the Mental Capacity Act 2005, which aimed to codify the common law by providing a statutory procedure for taking decisions on behalf of people who are unable to do so for themselves through mental incapacity. And they're referred to as P in the statute. The key features of the MCA, Mental Capacity Act, include that there are 6 principles on the face of the Act, and these are a presumption of capacity, A person must be supported to make their own decisions. A person may make an unwise decision. All acts must be done in the person's best interests, and there must be consideration of measures that are less restrictive of a person's rights and freedoms. So autonomy of P is at the heart, I would say, of the Mental Capacity Act. And the Act sets out a test for determining an inability to take decisions and a procedure for determining a person's best interests by reference to, for example, their wishes and feelings and the views of others involved in their care. The Court of Protection jurisdiction depends very much on displacing the presumption of capacity to make a decision in relation to a specific matter because of a mental impairment or disturbance in the functioning of their mind or brain. So this includes developmental disorders and brain injuries, whether permanent or temporary. So for example, decisions have to be made on behalf of people who are in a coma or persistent vegetative state, and those must be made in accordance with the MCA too. A large amount of the health and welfare work in the Court of Protection involves people with learning disability, autism, or dementia. Decisions taken on behalf of a P that come before a Court of Protection in its welfare jurisdiction usually engage convention rights. Article 8, respect for private and family life. Article 5, the protection and the right of the right to liberty. And that arises if restrictions contained in a care plan amount to deprivation of liberty, or a DOL, you may have heard that term being used. There's a convoluted set of procedures for authorising and safeguarding a P in that situation as required under Article 5, and these are shortly to be restyled and simplified as liberty protection safeguards. The UNCRPD, United Nations Convention on the Rights of Persons with Disabilities, is the relevant UN treaty, which is binding as a matter of international law and increasingly cited in the courts as an aid to interpretation. There are some significant tensions between the MCA and the UNCRPD, which promotes a social model supporting and enhancing decision-making rather than removing legal capacity. In a case called Cheshire West in the Supreme Court, Lady Hale, then president of the court, made powerful statements on the universality of human rights and the recognition of the CRPD by the Strasbourg court in this context. So the MCA sets a hierarchy of decision-making for people known as P. At the top of that hierarchy is the presumption of capacity, whereby a person makes their own decisions. Then there are provisions for individuals to appoint their own attorneys, lasting powers of attorney, or setting out their own advanced decisions to take effect on the loss of mental capacity. At the other end of the scale, if you like, is the court, which will step in where there's a dispute over decisions, usually around health and welfare, serious medical treatment, social care, contact with others, and the management of finances or property and affairs, signing a will, signing a tenancy. So a wide range of prescribed decisions. And it can decide on capacity and best interests and make appropriate declarations and orders on this range of specific issues. It applies the Mental Capacity Act to those aged 16 and over, and DOL safeguards under the Mental Capacity Act only to those over 18. So there's an overlap, and the Court of Protection intersects, for example, with the Turan Act in 1989 as children's transition into adult social care provision. There are also excluded decisions under the Mental Capacity Act, which are around marriage, sex, and mental health. The court can declare that a person lacks capacity to marry or to have sex, but cannot make best interests on behalf of a person on those issues, which I hope will be for obvious reasons. This has given rise to much litigation, and the Supreme Court is poised to give permission to appeal on a sexual relations case. The Mental Health Act exclusions relate to those who are subject to the Mental Health Act, so that the treatment for mental disorder is governed by the Mental Health Act, not by the Mental Capacity Act, if they are also lacking in capacity. So the ability to make decisions may be lost for reasons other than mental impairment. A typical example is where P is subject to an overbearing or dominant relative who is making decisions for them, potentially abusing them emotionally and financially, and is thereby unable to make their own decisions. This kind of coercion or undue influence is not usually satisfy the gateway test under the Mental Capacity Act, and so must be considered under the inherent jurisdiction of the High Court, by which the court is able to make protective orders to safeguard vulnerable adults and children, essentially when there's no other express means of doing so. So finally, you may also have read about the Court of Protection as a secret court, deciding intimate matters about people without proper public scrutiny. So court hearings are now subject to what are known as transparency orders, which permits the press and others to attend, subject to reporting restrictions, as are necessary and appropriate to balance the public interest against the private rights of P. So with that, I'm going to wrap up my overview. I think one final thought maybe is that I think court of protection work is important. I think it's about empowering and enabling people with mental disability to participate fully in their own lives. I think it's about independent living and deinstitutionalization. And there's a shift in thinking in relation to the lives of people with mental disabilities, which the court is there to support and promote. So with that, I hope that's enough. Thanks.
Thank you very much, Aswini. Very interesting. The next speaker is Nageena Khalique on serious medical treatment. Over to you, Nageena. I think you're muted, Nageena.
Good start. I'm so sorry about that. I'm Nageena Khalique, Queen's Counsel, and interestingly, I took Silk in 2015 alongside Vikram and Aswini. So there were 3 BAME candidates on that occasion. I think there are probably some more than that. I can't remember, but we ended up in a bit of a huddle. So Vikram suggested that we talk for about a minute about ourselves, and all I can say about my background is it's rather odd. I originally trained as a maxillofacial, well, as a dentist, and then went into maxillofacial surgery, where I ended up being a registrar in a hospital doing my own surgical lists, and then decided that this wasn't a career for me. So I took with me the experience in the NHS and that background into what I thought was going to be a clinical negligence practice, but I did crime for about 7 years. Before then I went into a broad civil practice, which included clinical negligence. And then I began to veer towards medical treatment decisions. I found that was my niche. And then with the Mental Capacity Act, there was a flurry of activity, and continues to be a flurry of activity. It's a very busy practice. So that's the boring bit about me over. And I'm now going to talk to you a little bit about serious medical treatment decisions and cases, and perhaps give you an example if I have enough time. Just to add, I can't stay for the Q&A at the end, but like Aswini, I'm more than happy for people to send questions directly to me if you want me to consider them. So the starting point for making medical treatment decisions, obviously the gateway to the jurisdiction of the Court of Protection is a lack of capacity, a lack of decision-making capacity. And once that's established, then one has to look to, first of all, Section 5 of the Mental Capacity Act. That provision provides a defence against liability for medical professionals carrying out whatever it is they're doing, including withholding, withdrawing treatment, where they reasonably believe that the person in question lacks the necessary capacity, and the decision and the act is in that person's best interests. So what does serious medical treatment mean? Well, some people will say quite a lot of things are serious medical treatment, but that's not what determines whether they should be brought to the attention of the Court of Protection. So generally speaking, if you're following the provisions of the Mental Capacity Act and you adhere to any professional guidance which is relevant to medical treatment in question, and also the Code of Practice, the Mental Capacity Code of Practice, then if those are all followed and everybody agrees about the decision-making process, that the person lacks capacity and that the best interests are not in dispute, then you can carry out that treatment or withdraw or withhold the treatment without an application to court. And that followed a Supreme Court judgment called NHS Trust and Why in 2018, where the concerns, there was certainly a lobby that was concerned about people who were in a permanently vegetative state and had been for years, and there was no benefit in any, or there was no prospect of them ever recovering, and the treatment was thought to be futile or burdensome, or there was no quality of life, that they were kept in this state for an unnecessarily long period of time. And when there was a consensus of view about what was in that individual's best interest, they shouldn't need to be an application to court. So if there is agreement, potentially, all well and good, but the situations where one might bring an application to court in relation to serious medical treatment cases is usually where there is a concern about the decision being finely balanced, or where there's a difference of medical opinion. Sometimes the family won't agree with the clinicians, or there is a lack of agreement as to the proposed course of action for those with an interest in the person's welfare, or a potential conflict of interest. In such circumstances, it's likely that you would have to bring an application to court. So examples of cases which might be brought to the court that fall into this definition of serious medical treatment, it's not an exhaustive list. There's a practice guidance that came out earlier this year from the Vice President of the Court of Protection, Mr. Justice Hayden. I think it was around February this year, but I'll happily be corrected if I got that wrong, but for sure it was this year. So the sort of cases which might result in, which will fall into this category of serious medical treatment is where there is a treatment where the primary purpose is for sterilisation. Just a reminder that may state the obvious here, we are talking about people who can't make that decision themselves. Where a medical treatment is proposed for, and the person lacks capacity to it, where the procedure is for the purpose of a donation of an organ, bone marrow, stem cells, tissue or body fluid to another person. Other serious medical treatment might be experimental or innovative treatment. It might be for the purposes of contraception or providing a contraceptive device, or where there's a significant ethical question that's in a controversial or untested area of medicine. Obviously that brings a world of medical issues and knowledge, which I personally find fascinating, and this area of work engages with that past experience I have. But you obviously don't need that past experience to really get stuck into the medical issues. But the involvement of sometimes really tricky ethical issues with the law is what I found particularly enticing. I'll give you a quick example in the last few minutes that I've got of a case which I just was involved with yesterday, and involved a gentleman who was diagnosed with chronic paranoid schizophrenia, which was treatment resistant. So much of the medication he tried had little effect on the auditory hallucinations. It modified it a bit, but they'd managed to get him to a level where they couldn't ameliorate all of the symptoms, but P, the protected party, the individual who lacked capacity, was able to live with, I think his name was Chris. So Chris was this voice that he often heard. Now, P developed an infection in his feet, which required treatment, but he was reluctant to have any treatment, and eventually it turned from an ulcer into a gangrenous foot. And by the time he was taken to hospital to have this foot assessed, there were limited options as to what could be done to treat him. And eventually the trust brought an application saying serious medical treatment that we're proposing is an amputation of his foot. This is what really gripped me about this case, and I'm sure it's true for certainly some of the people in this meeting today, because we've done cases like this before. But it was the dilemma and the difficulty that the court was had to make the decision ultimately to determine whether it was in his best interests. But first of all, the question which occupied the court for quite some time was to what extent this man was refusing to have the amputation, to what extent were his wishes and feelings driven by his underlying mental illness. In other words, it was Chris telling him not to have it. Or did he really lack capacity? Was he unable to make that decision? Because people with long-standing chronic schizophrenia, that becomes a feature of their personality. So the question was, well, what would Chris tell you about having continuing to live if you didn't have this amputation? So we had an interesting debate about the influence of Chris and how much of the wishes and feelings could be actually said to be genuinely felt, and whether we could separate this alter personality. Anyway, we moved on to best interests, and that was a matter of looking at Section 4 of the Act, which gives you a list of factors, again, not exhaustive, including past wishes and feelings and values and beliefs. And that's where we engage with the idea of how chronic paranoid schizophrenia affects your personality and ultimately your decision-making ability and your wishes and feelings. But other things that one considers there, including the medical opinion and those who care for P. And that's where we start getting into very interesting medical evidence, and sometimes quite grueling and galling to hear about ultimately what would happen at the end of life and how quickly one would die if sepsis developed. So that's a little bit of a canter through serious medical treatment, really only touching upon it, but you probably would find help in the practice guidance that, as I say, came out earlier this year as a sort of broad overview of the sorts of cases that come to court. And there's footnotes there which refer to the relevant rules in a few cases, which are quite illuminating. And just finally to say that I'm sure I'm not alone. It is a privilege to work in this particular arena, the Court of Protection generally, where the protection of rights and others, but even if you're representing one of the other parties, not necessarily the official solicitor for P, that the approach of this court is supposed to be, and generally speaking, is non-adversarial. It is very much about trying to make the right decision for an individual, having regard to their rights and freedoms. And those sorts of things not only interest you potentially medically, ethically or legally, but even just personally. There's often an occasion when I'm sitting in court listening about somebody's life in graphic detail, including how they might end their days and how their death may come about. And those are extremely I don't think I can find the word, but incredibly harrowing, but also illuminating. Perhaps doesn't really cover it, but the sense of feeling that you're really touching upon something that is deeply personal to anybody who's listening, but of course to the individuals we're concerned. So I think that's all I can say for now. As I say, I'm really happy if anybody wants to get in touch with me.
Thank you so much, Nageena. Fascinating. The next speaker is Peggy Etiebet, and she's going to speak on welfare. Peggy.
Mute. So you'll think I would have learnt by now, because since COVID started, 90% of our cases are online, and for every case you have, you're muted. Anyway, one point I wanted to make was just to echo what Aswini, the first speaker, had said, that if you look at the people before you today, you're probably not going to see this type of person if you're in a commercial case. And I just wanted to say I've spent 2 days now in a public law case, and 2 other counsel, judge, white men, solicitors, mostly white men. I think there was 2 women involved. So that is a stark illustration of what Aswini was referring to when she said the numbers start out quite high, and as you get higher up, they go down low. So it is actually, for me, when I came on, I was like, wow, a woman, black woman, this is a good thing. But so that's why we want to encourage more and more of you, you know, to come into the law and into COP work as well. I started out doing social and political science at Downing College, only black person there. I didn't have any problem with that, nor of difficulties. I went on to do the conversion course in law and then bar school, found that a lot more ethnically diverse. Then got taken on at Cornerstone, did pupillage, or second 12 months rather, pupillage at Cornerstone. We've got 60 tenants at the moment. I counted them up. In the bottom half, so in the bottom 30, we've got 6 BAME barristers. So out of the 30, we've got 6, and that's probably reflective of the general population. The oldest of those is 1998, oldest in terms of years of call, but above that we've got none. And I hazard a guess that that is also representative across the bar. So again, illustrative of the numbers going down, but hopefully, you know, as time goes up, doing things like this, that will improve. At Cornerstone, I do a lot of local government work, social welfare. That includes housing, homelessness, Care Act staff, so people that need support for care and attention, people who do so, but they've got no recourse to public funds. So, for example, as a result of their immigration status, they can't access public services, and then a lot of work in the court of protection. And what I found is that wide base of social welfare type work has really helped in the COP, because you're not just looking, particularly when it's a welfare type case, you're not just looking at whether they have capacity to make a decision, for example, as to where they live, but you're looking at the wider things. What kind of access do they have to housing? What kind of access do they have to care? As a matter of their immigration status, do they in fact have any access? So all those questions tie in. I actively chose COP eventually, and the reason was, I think, is as Nageena was saying earlier, is I like the inquisitorial nature of it. A lot of the bar, a lot of areas of law can be very adversarial. It is a game people are playing to win, and that's not the approach that at least I find within the COP. We are all working towards P's best interest. They are a vulnerable person, and you may have differences of opinion. I genuinely work for a local authority. We only have so much that we can provide. Perhaps person acting on behalf of P, the official solicitor, might want this much. And so there might be a bit of toing and froing, negotiation and persuasion as to what can actually be provided in P's best interests. But it is negotiation, persuasion, and trying to get the best for P in the real world. It is not, for example, huge cross-examination that you might see on TV where you're like really, that doesn't really happen. A lot of the cases get resolved through settlement, so you might not go to a final hearing. So if that kind of more, I wouldn't at all say it's more gentle, but if that kind of more inclusive work is what you're looking for, then I think that the COP is for you for sure. I made the point that I actively chose it because, again, if you're looking from a BAME perspective, it may be that some areas of law at the bar, they're perceived, you know, anecdotally, that have a greater proportion of BAME practitioners within it, perhaps because there's an easier access. So I'm thinking of immigration, for example, or criminal or family. This is perception. You know, it's anecdotal. I have no facts to back it up, but I don't find that in COP at all. To put it broadly, sometimes people say, oh, is immigration effectively a ghetto area of law? I wouldn't say that for COP at all. People fall into it or choose it because of their background. For example, as you heard from Nageena, because of her medical background. Dealing with welfare. So welfare encompasses everything. It encompasses whether people have capacity to have sex, capacity to get married, capacity to have contact with their friends, their family, their boyfriend, their girlfriend, capacity, big one at the moment is social media. Do they have capacity to access social media? Because the difficulty here in these types of cases, the person might be vulnerable and they lack capacity, but they may want to access social media and internet, as we all do, but what are they doing while they're on the internet? Are they, for example, because they're vulnerable, being groomed by the very, very large amount of naughty people out there, or because of their individual challenges, are they the ones that are perhaps speaking to young girls that they ought not to be speaking to? And so both parties in that kind of situation have to be helped and have to be supported. So those are the decisions, those are the facts that we're working with. It really is looking at someone's life and helping them. I just wanted to look at marriage, just to give you a bit more on that. Or sex first, let's do sex first. Effectively, it's a fundamental issue, fundamentally right, as some people would say. And so the courts are very, very, very cautious indeed when determining this, and particularly to find a lack of it. They very strive to have a non-paternalistic role in counter to what might have been around perhaps 50 years ago, where if you were disabled in some fashion, well, you know, sex was not for you. Now, you know, very much moved away from there, and the test particularly is so low because it's on the basis that, well, when we choose to have sex, we're not always thinking about it really, really, really carefully. And so why should the court hold a person who lacks capacity to a much higher level? So the test is low. They have to understand the mechanics of it. And this is not detailed. This is effectively man, woman, penis, vagina, one goes in the other. They have to, this is heterosexual sex, of course, they have to understand there's a possibility of pregnancy, again, in heterosexual sex. They have to understand the possibility of sexually transmitted infection. And again, they don't have to define that they may have syphilis, they may have gonorrhea, they may have chlamydia, just that they can get ill from having sex. And most importantly, that they can choose to engage in it. And within that is that they consent and the other person consents to it. We don't just, all parties don't just leave the individual to it. We provide them with education to support them to have this knowledge and to regain capacity in this area. But, you know, sometimes, you know, a capacity declaration is made that there is a lack of capacity for sex. In relation to marriage, again, a low bar, because this is a fundamental issue again. It's status specific, i.e. it means that a person lacks capacity to get married or to decide to get married, not to get married to Vikram, for example, because Vikram is a bad person. So it's status, not person specific. And we do not look at the wisdom of entering into a marriage. So that's, you're allowed to make foolish decisions. People lack capacity, allowed to make unwise decisions, it's called under the Act. And so we don't look at that at all, it's irrelevant. You just have to understand the duties and the responsibilities in relation to the marriage contract. For example, that there might be issues if you get divorced, financial issues if you get divorced. And again, you don't have to know that, oh, if we get divorced, it might be a settlement and I have to get a divorce lawyer, etc. You just have to know, if I get divorced, it may affect me financially because I'll have to give some of my money to my wife, if that's the case factually in your life. And of course, you have to have capacity to have sex. So those are two welfare issues. Just a few brief points on being BAME and the COP and money. So some of you may have seen, a couple of weeks ago, I think it was, in The Guardian, there was an article about female barristers earning less than male barristers, even in the same area of law and with the same experience they're earning less. I didn't look into what the actual documentary evidence was, and that's something as a barrister you always ought to do. So I'm just taking it as read from the Guardian article. But what is difficult as a BME barrister is you don't know what your colleagues are earning as such, because your clerks effectively sell you out and say, oh, they charge Peggy out at X amounts per hour. So you don't know what your colleagues are charging. But in COP particularly, if you're instructed, if your clients are local authorities, a lot of the work is on a schedule, it's on a program, you tender it out a framework. So if you're 0 to 5 years call, you will all get charged out at the same rate, 5 to 10 years of call, all at the same rate. So it makes it a lot more transparent and a lot more fair in that sense. things are getting better. So for example, in relation to race, I think it's only recent, though I may be corrected, the Bar Council is making chambers keep records both on whether you are disabled, whether you're a woman, whether you're a BME, and also about the fair allocation of work. So there can be the statistics to test this out, because there is, well, there may be implicit subconscious bias. We don't know, and unless we get the statistics to establish that, then it's difficult to address it. So it is a work in progress, and you know, I'm content that the bar is definitely moving the right way, and the COP bar for sure. The other issue is that the BME, and I think I phrased it invalidation. And I thought of this because, again, a couple of weeks ago, maybe a bit more, there was a Twitter storm about a Black barrister who was a criminal barrister, and she went to court one day and she was mistaken, I think 3 times in that day, for being either a defendant or similar. Basically, she wasn't observed to be counsel, and she was rightfully upset about this. And I just wanted to point out that in the COP, I've never experienced this. COP, particularly in London, they're small, they're lovely, it's almost like a family. You go there, they always remember you. So no difficulties at that at all. I must say, way back, it happened to me once, not in the COP, I think it was in the leasehold. I had ushered my clients in, all white men, so they know where to sit. And so I had come in last, and the tribunal were like, I'm not quite sure what they thought I was, but they didn't think I was counsel. I think they thought I was the legal, what's it called, paralegal. The person takes notes and carries the files. But it's not, you know, it's not my normal experience, and I've had no difficulties. I think I wrote some notes. I think that's about it I've got on my notes. Thanks, Vikram.
Thank you so much, Peggy. So the next talk is from Ulele Burnham, and it's on the crossover between the Court of Protection, admin law, and mental health.
Hi there, everyone. I'm going to talk about a little bit about mental health work, which I'm going to focus mainly on mental health work, which isn't in the Court of Protection. Because so far, you've had an overview of the kinds of things that get determined in the Court of Protection, and I'm going to look at mental health work more generally. So Vikram had asked us to say, belatedly, to say a little bit about ourselves before we started our presentations, and I, like Aswini, responded by saying I really didn't have any interest in talking about myself, so I'm going to have to make that up really quickly and also make it sound interesting. I practice probably 80% of my time at the bar in the Court of Protection, and I'm a member of a chambers that has a reputation for work which is focused on the promotion and protection of human rights and civil liberties, Doughty Street. And mental health law has always been an important aspect of the work we do in that broad field. I'm going to tell you a little bit more about that kind of work in a bit. Now, in relation to me, I also am what I would describe as a reluctant and ambivalent lawyer. I came, I did international relations and politics postgraduate level at university, and I was a graduate teaching student, Queen Mary, for a while before I came to the bar, and that was the point at which I thought I'd better try and find a way to earn a living. And though I have some, not regrets, but I miss the aspect of what felt a bit more like dispassionate intellectual interest and research. And there's a lot of intellectual activity at the bar, but it's very focused and concentrated on mainly the cases that you're doing. So it's directed at the outcome that you need to achieve, obviously, for your client, and so it isn't in that sense dispassionate. I also wasn't born here. I came here to study I come from Guyana in South America, and when I came, I intended to return, and some 30 years later, I'm still here. I don't know how I account for that precisely, but I couldn't possibly go into it today. So in a way, that's how I got here to the bar. And then looking at the question of Court of Protection work and why I do it. I think one of the other presenters tonight, Ruth, laughed and said, when we were talking about that, and I responded not dissimilarly to what she suggested, which is I got into it by accident. So again, and as Aswini alluded to that too, it wasn't pre-planned, but if I try to think about why it is that it's attractive to me, I think it's not unconnected with things that might concern people from Black and ethnic minority backgrounds. And it's this, if I think about it, if you're kind of interested in humanity, in difference, in different abilities, and in the need to make sure that rights, human rights or rights of access to justice, the law, apply equally to persons who are different and have different abilities, and who might have been circumscribed, whose life chances might have been circumscribed by, say, unjust perceptions of difference in status, etc., then in a sense, that is something that that you will find a lot of in work in the Court of Protection or in mental health, because that's what you are looking at. In general terms, the work we do is about ensuring whomever we act for, that's the overall process, ensuring that people of different abilities, perhaps with psychosocial difficulties and intellectual disabilities, aren't treated as less than human, and they're able to claim that elusive category we talk of as humanity. And the reason I say it's relevant to people from BAME backgrounds is, in some senses, certainly it's my experience, that if you are from a BAME background, you are no stranger to the experience of being treated differently and needing to attempt to achieve equality of treatment against a perception that your difference means that you should be treated differently, and that your life chances or your prospects of work or your autonomy, etc., should be restricted. Now, those are all things that in large part the law in this country has moved away from, but there are still struggles that have to be fought. So in a sense, if you have an interest in difference, and if you have a background of a lived experience of difference and prejudice, the Court of Protection and doing work which ensures that people with the kinds of disabilities we encounter are not, if you like, discriminated against in some senses, then this is an area of work which will come naturally to you if those are your interests, if your interests are in difference, etc. And I think, if I were to say so myself, I started off practice of the bar broadly doing employment law and with a focus on equality and discrimination, and moving into the Court of Protection seemed completely at one and in accord with my interest in equality and equality type work. I think, so in some senses, that's what I say there is to recommend it. And I like to think of the Court of Protection and mental health work sometimes as applied philosophy, because it's about actually thinking through principles of autonomy and about restriction and what different aspects of one's identity should mean in terms of what you are able to do and achieve and what you can be empowered to achieve. So that's broadly, I mean, I don't get to think like that every day in the Court of Protection, but that, if I'm to reflect on it, is what I find particularly interesting about this work. So I wanted to talk a bit about the Mental Health Act, because others have told you what the Court of Protection broadly is concerned with. And I wanted to talk a bit about mental health law as it arises in other jurisdictions other than the Court of Protection, or as it is determined in other jurisdictions. And really, to cut to it, there are a lot of areas of law in which mental health issues arise. But the other major piece of legislation in this country anyway is the Mental Health Act 1983. And what distinguishes it in some ways from the Mental Capacity Act is that the fundamental principles or the stare of the act, what underlies it, and the principles in accordance with which decision making occurs, those principles as between the two acts are different. In the Mental Capacity Act, as you've heard, running through it is the foundational, are the twin foundational principles of capacity and best interest. So the point is to make sure that people can make decisions as autonomously as they can safely and properly do. And so therefore, if they have capacity to make a particular decision, no one else should be making it on their behalf. And if they don't, then it should be made in their best interest. That's the broad scheme of that act, the Mental Capacity Act. In terms of the Mental Health Act, which many others treat or look at as a much more coercive piece of legislation, the principles or the twin principles of that act are to do with diagnosis and risk. So Mental Health Act is concerned with the assessment and treatment of mental disorder, mainly in hospital settings. The general steer is that assessment and treatment is provided under compulsory powers, where typically speaking, the person who has a mental the person concerned, called the patient in the Mental Health Act context, largely, has a mental disorder of the kind, which is a diagnostic question, which makes detention or the imposition of compulsory powers necessary for their health, their safety, or the protection of others. And that that trio of questions is usually looked at as the risk question. So risk and diagnosis govern the way in which that statute operates. And the issue of capacity and best interest, whilst it is relevant and it applies to decision-making under that act, that's not what ultimately determines the operation of that act. And on the whole, basically, and I realized in a sense how difficult it is sometimes to try and give an overview, a brief overview of this area of work to people who are perhaps not aware of it. And I realize in a sense that it's more difficult to simplify some things at times than it is to talk in more complex terms. But on the whole, the Mental Health Act, subject to certain procedural safeguards, how it works is if the diagnostic threshold is met, that is if the person is suffering from a mental disorder of a nature or degree, and that's outlined in the statute and in the case law, and the risk criteria are met. It's important they're both met. So that is that it is necessary for the health of that person, their safety, and the protection of others that they be detained or otherwise subject to compulsory powers. That person can be detained for assessment or treatment under the Mental Health Act, or, for example, be subject to a guardianship order under the Mental Health Act, which isn't about detention, but which is about the ability of normally a local authority to make decisions about where they might live or compliance with a medication or treatment regime. The policy of the Mental Health Act was described by the Court of Appeal in a case called Kay back in 1990 as to regulate the circumstances in which the liberty of persons who might be mentally disordered might be restricted. So on the whole, challenges to the operation of the Mental Health Act or on behalf of or in respect of a person made subject to its provisions are public law challenges. So it's not a challenge in the Court of Protection, which is a special jurisdiction. It's a challenge usually made in the administrative court, which is part of the High Court, which has a supervisory jurisdiction in relation to decisions made by public bodies. And so appeals, well, not appeals, rather, challenges to the operation of the Mental Health Act are broadly speaking in certain circumstances made to the High Court, the administrative court, the administrative division of the High Court in its supervisory jurisdiction. So it's worth noting too, however, and this is where it gets a bit complex, but I just say this so you know, if a person is detained under the Mental Health Act for assessment or treatment, they have the right to bring a tribunal, a claim before the First Tier Tribunal Mental Health, which is not the administrative court, which is a specialist tribunal. So challenges to detention are brought there and they can be appealed to the upper tribunal. But in the High Court is more concerned these days with challenges in relation to other matters to do with the Mental Health Act and not about detention per se. So what happens in the Mental Health Act, or in terms of the Mental Health Act more generally, and what does it cover, and what sorts of issues might arise if you are practicing in mental health law, which involves challenges made under the Mental Health Act or to the Mental Health Act. It, as I said before, it permits the use of coercive powers, such as treatment by way of medication without consent. And insofar as it does, it's not based expressly on capacity and best interest, but rather on the basis of the fact that the diagnosis, the risk and diagnostic criteria apply to the person such that they can be made subject to the Mental Health Act. And challenges of that kind, where they don't relate to detention itself, as I said, that goes to the first-tier tribunal, which is a separate tribunal, but challenges to do with the way the Mental Health Act has been used, such as, for example, a decision to compulsorily treat someone by way of medication, can be made to the administrative court. Now, the kinds of questions that might arise in relation to in mental health law, if you're practicing in this area, might be whether the admission criteria for detention are met. In other words, does what the statute requires, or has what the statute requires been satisfied by those who have decided to detain the person? Is treatment for a particular mental disorder without consent therapeutically necessary? And that may involve looking at principles that we find in the European Convention on Human Rights under Article 3 in relation to inhuman and degrading treatment, or in relation to Article 8 and the respect for private life. Now, there might be questions about whether there is a duty to provide aftercare services, or what kinds of aftercare services might be provided after someone ceases to be detained. It might be about whether a nearest relative should be displaced. And in terms of that, I'll just explain briefly that the Mental Health Act provides for a role to be performed usually by a family member, where they can take decisions which affect the way the Mental Health Act operates. So, for example, a nearest relative can discharge a patient from detention, even if the doctor says that they should be detained. There are other provisions which allow the doctor to bar such a discharge in certain circumstances, but the nearest relative rule is very important. And sometimes you can have cases where a local authority is attempting to displace a nearest relative or remove them because they have acted unreasonably in relation to discharge decisions, or they're unsuitable to act as a nearest relative. So that's kind of a broad view of all the kinds of cases that you can have to deal with. And these, like Nageena said, touch on really, really deeply personal decisions, but also touch upon the kinds of things that that many of us who perhaps don't have disclosed impairments make, or decisions we make for ourselves all the time. And you suddenly realize why, when you do this work, why there is a need to make sure that you actually rigorously examine the basis for differential treatment of those who have mental disorders or impairments of the mind or brain. So, and all of this can involve, for those of you who might be interested in human rights and civil liberties, this often involves the use of international human rights instruments, which have made a difference in the number of the cases that many people here have been involved in. For example, excessive delay before discharging a patient who is found by a tribunal not to be suffering from a mental health disorder can be a breach of the right not to be deprived of one's liberty under the European Convention, except as prescribed by law. So if you take too long to discharge someone when they don't have a mental health disorder which would justify detention, then that itself can be a breach of the right to liberty. So there are all sorts of things like this that come up in the context of mental health practice. So to close, I'm just going to say a few things about the distinction between the a few more things about the distinction between the Mental Health Act, for example, and the Court of Protection, or the Mental Capacity Act and the Court of Protection. In some ways, one of the easiest ways of describing the circumstances in which one act is used rather than the other, and it's very complex. I'm not even sure I'm on top of it, and I've been practicing in this area for some considerable time. But one of the main distinctions would be that where a person requires treatment for mental disorder to which they don't consent, and the criteria that I discussed in relation to diagnosis and risk are met, then it is usually the Mental Health Act to which they might be made subject, rather than being dealt with under the Mental Capacity Act. So this really, the Mental Health Act, if I were to summarize, and this doesn't cover every situation, deals with the treatment and assessment of mental disorder in circumstances where the person does not consent to that treatment or assessment and the criteria for the act are met. Otherwise, where people, for example, have psychosocial disabilities and they have impaired decision-making capacity, etc., then the principles that are to be applied generally, not just in relation to hospital or detention, the principles that are to be applied generally are those which are found in the Mental Capacity Act. And I think that about takes up the time that I think I've been allocated. And what I would say is that based on what the review that I've provided, and actually why the reasons I've given for my interest in it, if you have those kinds of interest, if you're interested in the promotion or securing of rights for those who are different, then I think this is really, really an interesting area to practice in. I mean, one of the things that I've been thinking about recently that hasn't come up so much is that there is obviously another area of practice that I have some knowledge of, which is equality and discrimination law more generally. And there is potentially an interesting overlap between that and the Court of Protection, insofar as it would be interesting to look at the operation of the Court of Protection and things that occur in the Court of Protection, and, for example, the Convention on the Rights of Disabled Persons, that Aswini mentioned earlier, in terms of domestic equality law, and to look at whether the way that we approach things in the Court of Protection does or doesn't work with the framework that the Equality Act rather provides for domestically. And so there are all sorts of areas for interesting adjacencies, it seems to me, of practice areas, if you're interested in difference, equality, and the protection and promotion of rights. I think that's all I think I can usefully say, Vikram. Thank you.
Thank you so much, Ulele. Very interesting overview of the crossover between Court of Protection and mental health. The next talk is on dolls, and Parishil Patel will explain to you what that means.
Thank you, Vikram. I missed Vikram's little pep talk in which we were told to talk about ourselves. And I'm, as he knows, very unaccustomed about speaking about myself. So I'll give it a go. I'll give it a go. I've been doing COP work since it basically started in its current form, which was on the 1st of October 2007, which was when the Mental Capacity Act came into force. So over 10 years. And I'm just going to tell you why I enjoy doing this work and why I do it, and why you, as aspiring lawyers and barristers, should do it and consider doing it yourself. 3 reasons, really. The first is it is extremely rewarding. And I know this is a bit of a pat phrase, and you're maybe the rest of the panel are all going to roll their eyes, but you genuinely do make a difference, a real difference to people's lives when you're doing this work. And you have a direct impact on a daily, if not daily, weekly basis. You're often acting as an arbitrator. You're often acting as a social worker. You're often acting as a doctor. you're often acting as a sort of concerned family member, because you've got a number of roles as a barrister in the Court of Protection where you're essentially trying to put what is highly charged emotional situations into some sort of logic, and the logic is all for the good of the person who is the incapacitated adult, what we in the Court of Protection whom we call P. You're trying to do the best for them, and that's all of your energy is invested towards that. The second reason is that it's not just about emotion, it's not just about pragmatism, but there are some genuinely complicated and interesting legal issues involved in the Court of Protection. I'll give you two that I've recently had to deal with. The first, and Vikram will know this as well, is in order to have capacity to consent to having sex, do you need to understand that the other person with whom you want to have sex is consenting themselves? Now that sounds like a really easy question to answer. Well, as Vikram will tell you, I persuaded one judge in the High Court, in the Court of Protection, and he persuaded 3 in the Court of Appeal. So it's 1-1 at the moment. And I'm sure there's going to be a panel of 5 judges whereby they're going to give their pennies worth and see who wins that particular debate. It's not as simple as you might think. It's probably not as complicated as I made it. But it was an interesting legal question. The second is, and it's very topical, it's about COVID. COVID has had a large impact on vulnerable people throughout this country, and you'll all probably hear the stories that have been going in the press. But one of the questions that I've had to consider and the courts had to consider recently is whether in lockdown, where you're not supposed to be moving, you're not supposed to be visiting people or gathering people, if you as a family member has always been that vulnerable person's carer and they live somewhere else, are you still able to go and see them? Are you still able to go and gather and meet them at their house in order to provide them with the support that you had been providing them before COVID? Well, if one looks at the regulations, and we've all unfortunately at times had to look at these lockdown regulations, not easy to understand, but we've had to. On one analysis, it could be said, well, no, because all you're doing is simply visiting that person, and that's the whole point of lockdown. You're not allowed to visit them. But I think the better answer is the one that I certainly gave to the court, and hopefully it will be accepted. We haven't had judgment yet. Is that actually what you're doing is providing invaluable care and support to that vulnerable person, and because you were doing that beforehand, you should be able to do it during COVID, because that's one of the exceptions. If a professional carer can keep going to support a vulnerable person, so should a family member. Anyway, those are 2 quite interesting legal questions. And then the third reason is that it's just always constantly surprising, this world, this practice. And again, I'll give you 2 examples, quite extreme examples, I think, from my last year in practice. The first is I've had a client die on me in the middle of a hearing. And Nageena will tell you, Nageena, who gave she was on the other side. We were in the middle of a 5-day hearing, and on day 4 at lunchtime, while she was cross-examining the P's partner, who was some 40 years younger than P. Perhaps he was after her money, but let's not make these sorts of things and make these sorts of allegations without much more. We got a phone call at lunchtime, and P had died. And that, I'm afraid, was the end of the whole case, because if you don't have a P, if you don't have a vulnerable person who lacks capacity, you don't have proceedings in the Court of Protection. It was a pretty odd feeling. And then the second was what happened to me yesterday, just yesterday. I was in a hearing, not remote. Peggy's right. We have done 90% of these hearings over the video, but just occasionally over the last 9 months, we've also gone back to what's normal court. And I was in normal court yesterday, cross-examining the father of an autistic adult, questioning the father about the benefits of his obese son's varied diet, which had been introduced by professional carers. They had introduced fruit and vegetables, and his son wasn't just eating pizza and chips, which is what he'd been his father had been feeding him when he had been looking after him. At that point, and the father turned to me and he said, well, he said, you should really understand why I give him pizza and chips, because you're chubby as well. And I thought, well, that's lovely, isn't it? You know, cross-examining somebody and then being called chubby in the middle of a hearing. But there we are. That's me. You know, that's one of the reasons why we do this job, actually, and it's one of the reasons why you really should consider coming to do work in the Court of Protection, because it really is, as I say, constantly surprising. Now, that's enough about me. And I can see Vikram laughing a lot. There we are.
You were only meant to have 1 minute on yourself.
Oh, God, sorry. I told you I was good at talking about myself, didn't I? Right, I've got to talk about dolls. And what you guys will soon find out is that us lawyers, we love acronyms. So, you know, what if you've got no idea what dolls means, well, join the club to most of us lawyers, because none of us probably had an idea when we first got told it, and we had to learn it ourselves. And what it stands for is deprivation of liberty safeguards, and it's in relation to a particular statutory scheme which authorises deprivation of liberty for vulnerable adults who lack capacity under the Mental Capacity Act. Now, what does deprivation of liberty mean? Well, most of you will know the obvious, which is, you know, if you sentence someone to imprisonment that's deprivation of liberty. If you admit someone to a mental health hospital under the powers of the Mental Health Act that Ulele was talking about, that's a deprivation of that person's liberty. But it can occur in places which you wouldn't expect. And some of those are situations in which we in the Court of Protection deal. Take an example, a vulnerable adult who is constantly receiving care and support in their own home, and they're receiving care and support for their own protection, for to ensure that they don't harm themselves, to ensure that they don't do something that endangers their life, because they are constantly receiving care and because they are being controlled effectively, they are deprived of their liberty. Now, you and I, if we were constantly controlled and put on and told what to do and said we couldn't go somewhere, and we agreed to that because we were able to do so, we would basically be saying, yeah, okay, yeah, I agree to being confined in that way. The reason why it becomes a deprivation of liberty for these adults is because it's said that they cannot consent. They lack the capacity to consent to the arrangements which mean that they are confined and deprived of their liberty. So Lady Hale came up with the best description of what it means, and because it was said before her in the seminal case in the Supreme Court when one was considering what amounted to a deprivation of liberty, said, well, how can you say that someone who needs these arrangements which control their the way they live, control their movement, restrict what they do, how can you say, and it's in their best interest, it's for their benefit, how can you say that's a deprivation of liberty? And she said a gilded cage is still a cage. And that's the point, which is that although it may be in their best interest and therefore under the Mental Capacity Act, the court, or under the statutory dolls scheme, best interest assessors may say, yes, actually this is to their benefit and this is necessary and proportionate in order to look after them. Those adults are still deprived of their liberty and so therefore would be caught by that scheme. Now, I think, someone will tell me if I'm wrong, but a very large percentage of welfare cases in the Court of Protection involve a deprivation of liberty of some sort. Ruth, who's much more experienced in these sorts of things and much more knowledgeable, has just been nodding her head, so I'm right about that. But I would say that in relation to the welfare cases that I do, I would say about 70% of those cases involve a deprivation of liberty. And usually, not always, but usually there is no dispute that there is a deprivation of liberty. The dispute is usually as to whether in fact it's necessary, whether in fact that person could be cared for in some other way which wouldn't amount to a deprivation of liberty, whether in fact actually they should be deprived of their liberty not in a particular place but in another particular place. Those are usually the arguments and the issues, and very rarely do we get cases that involve a real challenge to whether in fact somebody is being deprived of their liberty. But they do occur, and they still occur. And one of the things that is required in order to have a deprivation of liberty is somehow your confinement, your care arrangements have to be attributable to the state, because it's the state that is then essentially responsible for your deprivation of liberty. And that still does raise issues in these sorts of cases, because take the adult that I talked about who was living in their own home. Say instead of carers that the local authority or the health bodies were providing, so the state was providing, instead of that, it was that adult's parents or that adult's brother or sister who was actually providing the consistent and control and supervision. Where is the state element there? And those are sorts of questions which still need to be resolved. And those are questions which are interesting legal questions which have to be resolved, which takes me back to the second point about why we all do the Court of Protection. And that's because there are some really interesting legal issues involved. I'll finish with, I think I would like to support what Ulele said. I'm afraid I wasn't around when Aswini was speaking. I only caught the end of her. So if she said this too, I support it too, which is that for BAME people, the Court of Protection is a great environment to work, because as she said, it celebrates differences in people. It ensures that not only does it celebrate your differences, but that you are treated equally, even though you are different. And that is something that we all in BMAE, we understand. And so it's something that you should really aspire to wanting to do. And no more is that more exemplified than listening to Ulele's accent. And when she makes submissions, because you're not going to get that, I'm afraid, in the bar when you're talking about commercial law or anything like that. And it's just it's wonderful to hear it. Ulele's not alone. We have a range of different people. You'll fit right in, and that's why you should do this sort of work. I am sticking around for questions, so if you need to ask anything, do. Thank you, Vikram.
Great, thank you very much, Parishil. The next speaker is Ruth Hughes, who's an expert on property and affairs, and she's going to talk to you all about it. Ruth.
Thanks very much, Vikram. Well, my practice is quite different from everyone else who has talked before, because I have a traditional chancery and court protection property and affairs practice. I practice from 5-stone buildings, and if people ask me what I do who are non-lawyers, I would generally say I do dead people, mentally ill people, and tax. And some of the highlights of my non-court of protection career involve representing 22 highly endangered Chinese tigers in a divorce in the Court of Appeal, and cross-examining on the closing of the contracts on Avatar, the film, in a £1 billion tax case. So that can be quite a different kind of texture of practice from the court of protection work that I do. But I feel like there's a continuity between the property and affairs work that I do and the other chancery and tax work. So I did, as was said earlier, completely fall into the Court of Protection by accident. I thought that I was going to be doing a trusts pupillage, you know, the rule in Shelley's case, Saunders and Vautier, Stack and Dowden, those kind of exciting things that you've learnt about in equity. And to a certain extent, I did do that. But I found myself in October 2007, the new Mental Capacity Act had just come into force, and I was the pupil of the preeminent property and affairs practitioner at the English bar, and I had no idea what the Court of Protection was, so I had better learn pretty fast, and I did. And I have always done a substantial amount of property and affairs work since I qualified as a practicing barrister, and I have almost always, although not exclusively, acted for the official solicitor who represents the person that lacks mental capacity in the Court of Protection. So what is Court of Protection property and affairs work? Well, it's really about control of property. It's about deputies who are court appointed, or attorneys who are appointed by the person who has come to lack mental capacity before they lacked mental capacity, managing that property. It's about distribution of property through gifting, trusts authorised by the Court of Protection, and wills made by the Court of Protection called statutory wills for somebody who lacks testamentary capacity. And that can be quite technical work. I could draft you a will on the back of a fag packet. I have done that. It can involve quite a lot of other sorts of contentious private client work, because you might want to use a statutory will to solve a potential post-death dispute. So you have to know all about contentious probate, family provision under the 1975 Act, proprietary estoppel, mutual wills, that kind of work. And there's quite a bit of financial abuse that goes on, and I deal with some of that. Once there was a case in which there was a man called Mr. Greedy, and he stole all the money, which was nominative determinism at its very best. And it's been said that the Court of Protection can be quite collaborative. Well, it's not if you've got a financial abuse case. I have cross-examined hard, asked someone why it was that they couldn't tell me how many watches for £10,000 they'd bought for P. Do they often go into shops and buy watches at £10,000 a piece? And why did P need these things? She was in a care home. It was actually a really sad case because it was one of the worst care home rooms that the official solicitor's representative had ever seen. And these people have been going out buying heirlooms for P, laptops to do P's accounts on, and for some reason a mini countryman in order to visit P. There's really no limit to the amount people can financially abuse others, and it's very sad, but it is good work to stop them. You can get injunctions to prevent financial abuse, you can remove people as deputies, and you can bring claims in the civil courts to recover the money. So that's the kind of work that I do, and it's more akin to private client litigation than what other people who have spoken have done, and it involves skills that a non-contentious private client lawyer might have as well. So today I was advising on whether it was in P's best interests to make a gift for tax planning reasons of some money from a clinical negligence award of £14 million, which had been made quite recently to him. Spoiler, absolutely not. So that can sound quite dry, but I'm here to persuade you that it isn't dry and square at all. When I finished my pupillage, one of my pupil masters said that he thought I would enjoy the work because I had an eye for salacious detail, and so it has proved. So this year has really been the year of the celebrity court of protection practice for me. A couple of months ago, I made a statutory will for a film star. He had a wife that was much younger than him, and you don't know who it is, so I can say without causing any defamation that she was definitely in it for the money. And I'm currently doing a case where I'm acting for the daughters of a tycoon. He's nailed on A-list celebrity, and it was said that, you know, it's not hard-nosed litigation. I wish someone would tell the other side. In this case, it isn't hard-nosed because it's verging on psychological warfare. So it's that's about his lasting powers of attorney. What else have I been doing recently? Well, I acted for a mistress. She had been P's mistress for a long time. She divorced her husband, and P, when he had capacity, had said that he would support her, and so she hadn't claimed financial provision from her ex-husband. And P did provide for her. He stood by his word. He bought her a house. He paid for her monthly outgoings and all her private hospital bills until he lost capacity. And then you know what? His wife didn't seem that keen on continuing the maintenance, so he had to sue her. Because it was definitely in his best interest for the maintenance to continue. It's what he would have done if he hadn't lost capacity and it was in accordance with his moral obligations. What else? I made a statutory will for a aristocrat who had had some problems with alcohol. Unfortunately, his marriage broke down. He was a very lonely man, and he was living in the basement flat in Fulham. He did have properties elsewhere, quite a nice country pad in the north of England, and a castle in Scotland. He had a carer who was Croatian. Viewer, he married her. She was also in it for the money. She also produced a forged will, and we had to sort this out. It was quite difficult. The marriage in England, at least, revoked the will, although the Scottish lawyers said it wasn't revoking the Scottish aspects of the will, which was quite interesting. But, you know, you should never look a gift horse in the mouth. And we said she'd been living here for a long time, and she said she didn't acquire a domicile of choice in England and Wales. So that meant we could reroute the entire estate through her. She was much younger, no surprise, and get inheritance tax relief on all of it. We could provide for her with for much less than the £5 million of inheritance tax we were saving. So the job was a good one, really. And that actually made a big difference to P, because as a result of putting his affairs on a sensible footing and getting a professional deputy for him, they were able to find him a much more sensible property. He couldn't get out of the basement flat in Fulham. And so now he's got a roadside property that he can go get out of the house from, and now he lives with his wife. There are cases that are much sadder than that. I acted for a child who was dying. He was very unlucky. He had suffered from clinical negligence at birth. His mother was unable to cope. He went into foster care. His foster mother died. But as unlucky as that was, he was amazingly lucky that the foster mother's daughter took him into her home. She had a young family and she dedicated herself to his care. It was really a case of the extraordinary ordinary. But he was dying. He owned the house they lived in because that's the clinical negligence award had funded it. And if he was going to die, she wasn't going, and the family were going to get thrown out. So his deputy applied for a statutory settlement because he was under 18. She can't make a will for him, to provide for them. But the birth mother disagreed. She was quite difficult. She made scenes at the hospital where P was dying. And there was also a father who she said she knew. He had said that he wasn't P's father, but we needed to notify him anyway, so that he could, if he wanted to make submissions, we had to notify him over Facebook. And we were able to make a statutory settlement that provided for the foster family within days before P died. And there was some interesting law that arose out of that as well. I was able to refer to some of the early statutory settlement cases, which were the precursor to statutory wills in Part 7 of the Law of Property Act, which is the Married Women and Lunatics section of the Law of Property Act 1925, and we've come some way since then. There are very interesting kinds of cases. There are interesting kinds of families that you will see if you do property and affairs work. I have a case at the moment where I'm doing statutory wills in a case where there was essentially a ménage à trois, and the children of the marriage are arguing that the third party was unduly influencing their father and mother into making those wills. There's really no end of interest to the way families are and they live, and that's at the core of private client work. I would say that I find my Court of Protection Property and Affairs practice to be exciting, intellectually challenging, and very well paid. So I would say it's also combined well with a traditional chancery practice, which I would also commend to you. So I hope you agree, Vikram, that it's not all too boring in the property and affairs area.
Well, no, particularly since we have a very exciting case together, which will hopefully make some news later on next year. Right, Ruth, thank you so much for that. That was very interesting, and we can see why a career in property and affairs could certainly be of interest to quite a few of you, so do look into it. Now, finally, we have Turan Hursit talking about pupillage. Over to you, Turan.
Thanks, Vikram. And thank you everyone for sticking around for the graveyard slot of today's talk. I'm very grateful for those who've stayed on, which actually is a majority, so that's great. And thank you also to Ruth for definitely being the entertainment of my week with the salacious gossip that we've had. So I am the baby of this group of people, and I'm here today to talk to you about the bar, well, getting into the bar, doing pupillage, and the very baby junior end of the COP bar. To give you an outline of my background, first of all, which I think is important to do because we're not all kind of the traditional barrister. I've got quite an interesting background. My grandparents moved here as refugees in the 1950s because my granddad was told he would be killed if he didn't. They moved here literally with one suitcase. My dad grew up in a council flat of about 10 people. I was very lucky when I was growing up insofar as I didn't have any exposure to any of the kind of life-threatening things that people had suffered when they were growing up in my family, but I certainly grew up listening to war stories about really awful things, and in a very, very small but happy home with not much by way of monetary income. So my perspective is very much from the person of Turkish Cypriot ethnic origin with not very much growing up. And to many of you looking at the bar, I suspect you ask yourself the question of, is this really for me? Is it for someone like me? And my answer to that is always yes, because you can make it a profession for someone like you. My general background is that I went to a state school for both primary and secondary school, though I got into a grammar school for secondary. I was very lucky to do so because my parents knew absolutely nothing about the education system. And I went on to study law with French law at Bristol. I did a master's in public law at the LSE. And I worked at the European Court of Justice for a while on a scholarship from the court. And I then went on to do some bar training at City Law School with a full scholarship for the sum of the bar training course, which at the time it was extortionate and I suspect still is. So in that sense, I didn't come from another profession first. This was my first profession, but it was no easy feat to get here. The bar is it's extremely competitive. I think we have to be very, we have to be very honest about that. There will be, if you look at the statistics, there will be potentially several hundred applications for one spot or two spots on a pupillage programme, and you may have to apply on 1, 2, 3, 4 occasions to get through. I only got pupillage on my second attempt, and I made 18 applications to 13 chambers, did 18 interviews. I got one offer and I was a reserve at one other chambers. And that's not uncommon. That's probably one of the better statistics. I would say I was quite lucky in how it turned out. There are people I know who only really got something 3 or 4 years down the line. So it's hard. It's really hard. And you have to graft to get there. But it's an incredibly rewarding profession that you will adore once you get here, despite the very hard work. So how do you get there? I'll start from the very basics that Ruth has asked me to address about how to become a barrister. And somebody's asked this in the questions as well. Some of you, maybe not all of you, will be aware of the barrister-solicitor distinction. A case usually starts with a solicitor who takes charge of gathering evidence, asking the right questions, and progressing litigation with a view to settling cases. And with some exceptions, it might stay with the solicitor. It doesn't go to court. You might never see it. But when litigation comes to the fore, the barristers become involved. We are litigation specialist lawyers, and I say litigation in the very broad sense, in that in a court of protection context, it's non-adversarial. But we only really become involved at the end of the process when everything else has been tried and may not have worked. And for example, solicitors will often come to barristers for advice about whether a case should go to court, whether an application should be brought at all. In terms of the route to the bar, there are a few different routes you can take. You can do a traditional law degree, 3-year law degree, 4-year law degree, which is what I did because I did a year abroad in France. And then the shortest route is to do that course. You do a 1-year barrister training course, as it's now called. Back in my day, it was the bar professional training course, but I think it's had about 10 different changes of name in the past 20 years. But then that's the vocational training period of 1 year, where you will study things like civil litigation, criminal litigation, and advocacy and opinion writing skills. And following that course, there is then a 1-year pupillage period during which you undertake a year's training in chambers with barristers, where you shadow barristers, you learn how to do the barristerial job, and ultimately at the end of that, it's decided whether or not you're taken on. So the shortest period of time you're looking at is 5 years. To be honest, it takes most people longer because they do things in between. I did a master's year, I did a year when I was working at the Court of Justice, and I did kind of various internships with NGOs. It's not uncommon to see people who have done a few things in between, or even come from other professions, as many of the panel today have done. So don't be in a rush. I would say it's really valuable to get a few years experience before you come to the bar, especially for the Court of Protection bar, when actually people want to see a bit of life experience and common sense. Often, it sounds a bit silly to say, but you know, when you're 21, 22 years old and you come out of law school very fresh-faced and with far fewer grey hairs than I'm starting to develop at the raw age of 28, it's, you know, it's quite, you will be naive at that age. You might not quite appreciate the gravity of the subject matter you're dealing with, and it really is important stuff that's being decided in the Court of Protection and elsewhere. So it's always nice to have a few years life experience under your belt before you come to advising on those matters. And I think from a very practical perspective, it gives people a bit of confidence in you to know that you're old enough to understand those things. So don't be in a rush is my first piece of advice. The second thing to mention in relation to bar training and pupillage is that for bar training, you don't have to be rich to do this because there are ways of getting that money. There are a huge number of scholarships that are awarded by the Inns of Court. There are 4 Inns of Court that you have to join when you become a barrister, who are responsible for providing you with your professional training throughout your career. And each of those inns runs a scholarship scheme whereby they sponsor you, you know, in particular sums of money to do the bar training. I was very lucky. I got a full scholarship from Inner Temple, and I specifically applied to Inner Temple because I knew it was partly means assessed, which for my, you know, from my background helped me probably. But yes, there's information about that certainly on the Inn's websites, and I would highly, highly recommend that everyone, regardless of means, even if you're better off, that everyone applies for them, because the scholarships are, they're a kind of rubber stamp on your CV. By the time you get to pupillage, you've already been in front of a panel. There's a panel who thinks you're good enough to get a scholarship and who therefore thinks you're good enough to succeed as a barrister. So don't just see it as a monetary thing. It's also, you know, it shows that you're able to, you know, some people have got faith in you. In terms of the actual scholarship process, there is an interview of about 15 to 20 minutes for each of the inns, as far as I know, and which follows an application form that you have to submit. And it's only those 2 things that are looked at. So it's quite a short process. The deadlines are usually in around November of each year, and you apply a year in advance. So, you know, if you're in the final year of university with bar school to follow the year after, you'd apply in the autumn of the kind of beginning of the 3rd year. I think the advice I would give for that process is that most of the questions in those interviews are quite predictable. They're things like, you know, why a barrister rather than a solicitor? Which area? What was this mooting problem that you mentioned in your application? What did you argue? What was interesting about it? What kind of minis have you done? Mini pupillages, which are the 1-week training kind of work experience schemes that chambers run. And why did that make you interested in this area? So you can prepare for these things. There are obviously unpredictable questions as well, but there's a certain core number of predictable questions that you can prepare as a, you know, before you go in. In terms of pupillage, pupillage at all of the sets, and this goes beyond the Court of Protection bar, is quite a lengthy process. You have an application form that you either submit on the portal, pupillage portal, to a certain number of, I think a maximum of 20 chambers now, and there are also sets you can apply to outside of that portal. And you'll be asked 150 word questions, interestingly, about things like why you want to be a barrister and why you're applying to that chambers. Again, the key to those is brevity, which I'm probably not exercising very much in this talk, but people want to see not just what you're putting in the application form, but how it's written. How can you express a persuasive point in 150 words? You know, how convincing are you within such a short paragraph of information? That's the kind of thing that they're going to be looking for, you know, across the board, not just in the Court of Protection. And I would recommend that those watching who are interested, that you all make a plan of what you want to include in each section, that you treat every application like a load of submissions for a case, where you are aiming to persuade the reader of your abilities, and you start drafting early. I made the terrible error in my first year of applying of leaving all of my applications to 1 week. And it was the worst thing to do, because it's the kind of thing where you need to reread it to see if it makes sense. And the more you read it, the more it's, you know, you're not going to pick up on things. So you have to have a break between each phase of drafting, as sometimes we do in the ordinary jobs that we do now. So that's a piece of advice for you for pupillage. In terms of doing pupillage, well, to be honest, every chambers has its own pupillage programme, but usually you would expect to see around 3 or 4 different supervisors in the course of a year, potentially in different practice areas, though some chambers are more specialist than others. And you will expect to shadow them on a very regular basis in your first 6 months of pupillage, which is the non-practicing period. And you will be on your feet as a barrister in the second 6 months of pupillage. I distinctly remember the first day I ever went to court, and I was absolutely terrified. And it was an awful case about a very simple case about a debt recovery. And I was acting for the horrible people recovering the debt and going to court to tell someone they had to pay me $5 grand. And it was terrifying, but you get such a thrill afterwards, when you come out of your first day of court and you've won it, or even if you've lost it, you've still got through it. So yeah, it's a really great feeling. The thing to say about I suppose pupillage generally is, first of all, it's probably not going to be fun, because it's a year of assessment. It's where, however nice the people around you and however lovely your supervisor and however great the work, it's a scary process being interviewed for a year, and being told you need to improve on this, or you haven't done this correctly, which you will be, because it's ultimately a learning curve. But don't let it get to you if you're in that position. This whole profession is a learning curve. I'm now 3 years cool, and I still feel like I don't know what I'm doing on most days, and I can probably say that of most people my age and cool. And if it feels like you're not succeeding at first, don't let that get to you, because it's totally it's a part of the entire process. The other thing to say is that you are not bound necessarily by the first chambers you may do a pupillage in. There is something called a third six pupillage that you will potentially come across, where you do 6 months after your 12 months at another chambers, if you decide to move, or if you're not taken on at your current chambers. And so there's never really, there's not an end of the road just because you haven't been taken on one place. There is a whole host of other chambers out there that you can go to. In terms of the COP bar specifically at the very junior end, it is a very specialist area. So there aren't quite as many chambers that do court of protection work as you would necessarily expect to see in other areas like commercial or general civil or even criminal. It's there's only really a handful of places that do that work, but it is, as everyone on the panel has said this evening, it's very rewarding work even at the very junior end. And as a junior, I say junior, I should really say put 5 juniors there for someone like me. As a baby junior court of protection barrister, the kinds of things you can expect to be doing are, first of all, what we call Section 21A applications, where you've got someone who's deprived of their liberty under the Mental Capacity Act, by way of standard authorization, and they are usually stuck in a care home. They don't want to be there, they want a bit more independence, and the matter goes to court for a determination from the court of where it is in that person's best interests to reside and receive care. And it's not necessarily always an 89-year-old dementia sufferer in a care home, but you know, that's quite a big proportion of what the baby junior bar does. I was very lucky to get a very interesting case a few months ago, which turned into a serious medical treatment case, about an amputee who had an infected leg wound. He'd had his leg chopped off, and we weren't sure if he'd been properly capacity assessed before that was done. It went, you know, yeah, exactly, Rosie. I see that, raised eyebrows. We had to check. We weren't notified of it until I was acting for the official solicitor who acts for the person who lacks capacity, and we weren't notified of it until after the leg had gone. And there was then a query that arose because he was refusing treatment of an infection of the leg wound, which could well have led to him dying. So it became a serious medical treatment case, became very exciting. And actually, I think another member of this panel was eventually involved in the later part of the case, because I ended up passing it up to someone more senior for parts of the case, which you will often do where it becomes, you know, a serious medical treatment case in the very, very early years of your career. But it just goes to show that there are still some very interesting cases. It's not just bog standard care home care home detentions. I had one today about someone who was a diabetic who kept almost died because she was over administering medication and underdosing on it as well. So yeah, there are really interesting cases even at the early end. I suppose the one downside to the COP bar at the junior end, to give you the full warts and all analysis, is that there isn't necessarily as much adversarial cross-examination or adversarial style litigation that some people might prefer. So a lot of my work is, I do a lot of interim directions hearings where it's a 1-hour hearing. We're making civil submissions on what we would like to see done in the next steps of a case. And there is a lot of that at the junior end. There are, few contested hearings probably in the first few years of your career, which I suspect increases the more time goes on and the further down the line you are. The upshot of that is that if you're someone who enjoys things like negotiation, mediation, working collaboratively with other parties, then it's probably an area you will enjoy, because it's not just about the fight and the win, it's ultimately about somebody's life. And I suppose that's what, that's part of what makes it so rewarding, and what makes you get out of bed in the morning. The most crucial skill for me in this area is pragmatism and creativity in finding solutions. So many of the issues that arise, certainly at the junior end, are very practical issues of, for example, how best to facilitate a trial visit home for someone who's stuck in a care home, who's objecting to their placement and actually wants to go back. Whether there are any practical measures that can be put into place to improve someone's quality of life in their existing placement. It's not just law, it's all about joined up thinking and whether you can come up with a practical solution to someone's dilemmas. So that's that's a brief overview of your the journey that you would need to take to get to the bar and what things look like at the bottom end of the Court of Protection bar.
Turan, thank you so much. That was extremely interesting. So I hope you're all feeling encouraged that you must apply and try again if you don't get it the first time. Right, so we now have some questions. Feel free to ask some more, but let's start with how about, when would you apply for a scholarship? Now, I can't remember because it's such a long time ago I applied, so I'm not going to try and answer that.
I can probably answer that. So as I said, the scholarships usually, the applications are usually in November. So I think this year the deadline was the 7th of November or around then. So I would start looking at the scholarship applications, you know, in September, October time, because it's quite a long application form depending on the inn. In terms of when in your kind of university time you would apply, I think I applied during my master's degree. So it was November of the autumn term of my degree for a scholarship that then applied for the following year. Ultimately, I ended up deferring it by 1 year because I got an offer from the Court of Justice, and that's something that some inns allow, not all of them. But ultimately, usually you would be looking to apply 1 academic year before you're due to start the bar training course.
Right, so that's one question. Another question is, can you apply for multiple scholarships and pupillages from different inns? I think that's slightly confused because you don't apply for pupillages from inns, but scholarships from inns. Can you apply to more than one inn and for more than one type of scholarship?
Shall I take this one again?
Well,
yeah. That you don't, so you can only apply to one inn. But if you don't get a scholarship with that inn, it's open to you to apply to another inn the following year, because you don't have to join the inn until you've heard about your scholarship. So if you're going to accept an offer from an inn, then you have to join and you pay a fee of about £120 or something. And some inns give you a scholarship for that as well. Certainly Inner Temple did for me. But yeah, that's that part of the question. As to pupillages, as Vikram's highlighted, the pupillages don't come from the inns, they come from chambers. So they are the barrister equivalent of law firms, where you know, where you would do your 1 year training period after the bar course, and the usual application procedure is either via the centralized pupillage portal, which is the case for most of the chambers, and you apply to up to 20 of those, or some chambers have their own individual application processes, and I think that information is usually available on chambers' websites.
okay, third one, and I think it might even be you, Turan, again. I'm currently doing my LPC. Can I apply for pupillage or mini pupillage?
You can apply for mini pupillage at any time and at any stage. So as long as you're a university student or above, and in fact, I think I even did one right before I went to uni, you can do mini pupillages. And again, the application procedure is usually on each individual chamber's website. Pupillage, you can be doing the LPC in order to apply, but you have to do bar training the year before you start pupillage. So you would need to time it so that your LPC finishes and then your bar training begins and then pupillage begins. But because pupillage applications are, I think now, a year and a half in advance of when you would actually expect to start, I think you could maybe time it so that you could, you know, you could apply at that point. I think now, if anyone correct me if I'm wrong, but I think now the applications are in around January time, and then you start your, you would start the pupillage not in September, but the following September.
Right. Ruth, what speciality stroke niche do you operate in?
So the posh way of calling it is traditional chancery, and what solicitors might call it is private client litigation.
Jarndyce and Jarndyce.
Yeah, exactly. If you want to know more about Chancery, there's a Chancery Bar Association. They have a careers booklet. It's quite good.
Or you could read Charles Dickens. That's the other way of doing it.
I mean, it's basically up-to-date law.
Yeah.
Vikram.
Right. Turan, you're proving very popular here. Can you please expand on the process? I'm feeling offended by this, on the process of getting an internship at the European Court of Justice.
Yes, of course. So I don't actually, well, I don't know if this still applies because now we've of course left the EU, but when I was applying, there was a centralized application process, which was called the Blue Book European Court of Justice application process, where you apply for one of 3 kinds of traineeships. Mine was a research traineeship, and you just do an application form. There was no interview or anything, and I think the figures were about, I think my year there were 54 applicants for my particular position, and I went there as kind of the British delegate to the research department. There are also, outside of those centralized traineeships, there are also unpaid traineeships with the individual judges of the Court of Justice, which are advertised in what is unfortunately a very opaque way on university websites. But I don't, you know, they're unpaid, and Luxembourg is quite an expensive place to live, and probably not the most exciting place to live either. So yeah, just pinch of salt there. But if you are interested in the centralised scheme, then just Google the European Court of Justice website, and I think the information should be there if that's still running.
All right. Question for perhaps Parishil. What's the best way to stay up to date with the current legal debates that come under Court of Protection?
Twitter.
Twitter.
That's yeah.
One word.
Essex newsletter.
Twitter is really the best way, I promise you.
But better than our own Chambers newsletter, Parishil. You've got another chance to answer that now.
Put it first equal, perhaps.
Okay.
So 39 Essex Street or Essex Chambers newsletter, first equal with Twitter.
Is that all? Do you want to have one final go at that one?
No, I'm fine. I mean, you know, come on, I'm modern. I'm forward looking.
I can see that. Peggy Etiebet, what would you say about that?
Well, to be honest, when I read the question, I said Twitter as well. You follow 39 Chambers on Twitter.
Okay, both.
Because it's easy. You want to keep up to date in an easy, quick way, don't you? So if you get Twitter, you've got a little bit, so that just comes up.
Okay, Twitter. Ruth Hughes, have you heard of Twitter?
Yes, I have heard of Twitter. However, I tend not to get my legal updates through it myself.
Oh, I see. Right. Okay. Anyone else? Ulele.
How remarkably traditional, Ruth.
Twitter.
Put the traditional and traditional.
You're muted, Ulele.
I think actually the most helpful way is the 39 Essex Court.
Someone said it.
And no one's not supposed to actually advocate for other chambers.
No, definitely not.
Basically, it's the best resource. I mean, that's if you can't abide Twitter. So,
so it still comes behind Twitter.
I mean, it depends on how sensational you want to be as well. If you don't want to be that sensational.
We're much more sensational, aren't we?
You, Vikram, or
our Chambers, yeah.
Okay, I'll leave that.
Right. Turan, do you have a view on keeping up to date? What's the best way?
I think there are some, well, yeah, I must say the 39 newsletter is of course excellent, but there are a whole load of blogs that you can sign up to.
Yeah,
I mean, I'm signed up to the UK Supreme Court blog for kind of overview of all Supreme Court cases. There's the UK Human Rights blog that's run by One Crown Office. There is, of course,
the Small Spaces Lucy's series blog.
Yes, yes. There's the Celia Kitchinger's Open Justice project, where she goes, probably mispronounced her name, but she goes to watch court of protection cases and reports them in a way that's of course compliant with transparency requirements. So yeah, there are all sorts of things out there. LinkedIn is also a really great information sharing resource. If you are connected to a practitioner on LinkedIn and they post updates, I mean, I see a lot of my stuff from there, but it's yeah, there's a whole load of stuff you can do.
Right. Okay. What about, are there any specific personality traits, stroke characteristics that you find, Parishil, are suited to the court of protection bar?
Yeah, I mean, I think you need to want to be able to find solutions rather than entrenched positions, because there's no point turning up in a court of protection case and going, well, I'm right, you're wrong. That's the end of the story, because you're just not going to get anywhere. So I think as a personality trait, you need to be focused on finding solutions, wanting to help, being creative, I think is very important. And this is the case for most barristers in most fields, but you've got to be personable. You've got to be able to talk to almost anybody.
Right. Is that true in Chancery as well, Ruth Hughes?
Being personable is very important.
Is it?
I would say so, yes. You've got to be nice to the clients.
Okay. No one else then?
No.
Okay.
But it's also, I guess, important. There's a lot of intellectual rigor technical skill. You have to be good at black letter law, particularly the tax. It's quite hard. So that's important too if you're doing property and affairs kind of work. I think it might be sometimes, particularly if you're acting for one of the parties that isn't the person that lacks capacity in property and affairs work, there might be more forceful advocacy, more cross-examination, but actually an understated reasonable advocacy often does go down well too.
Right. Peggy, characteristics.
I was going to add attention to detail. I think probably all barristers across all areas need that, but you'd be surprised as to, you sometimes in the cases I deal with, personal welfare cases, you get the daily records. So you've got a daily record of P's, well, daily, and you have to follow it through to see, for example, have they been distressed when there's a particular carer there, or perhaps it's a family member if you're doing a contact case, to see if the family member might be causing that distress in some way. So you're making your way through these masses and masses of paper. So detail, definitely.
Has it ever made a difference in any of your cases that you've read the papers carefully? Or is it just potential, stuff you've got?
There is the potential, because before we go into court, Vikram, I have negotiated and persuaded and acted as an arbitrator and as a mediator. We come to a solution that's happy for everyone.
Right.
So often now.
I have definitely found smoking gun documents buried in the middle of the bundle.
Really? No, so it does quite often help to read the papers. And if you haven't, in a way, if you're acting for someone and you're sent some papers to read and you go to court, I think the client is expecting you to have read them, but maybe they don't understand the significance of it sometimes, but it is very helpful to read the papers. Another question is, hold on, Ulele, I haven't asked about characteristics.
Well, just before you do, Vikram, I think it's part of our job to read the papers. Sorry, it's not optional.
Yeah.
That's what we have to do.
Yeah.
Okay. Glad we've clarified that.
Yeah, I mean, I think we need to.
Yeah, we do. I was going to ask why Vikram was inviting Peggy to suggest that she made a choice about whether she read her paper.
I was trying to provoke her, but she didn't rise to the provocation, unfortunately, because Peggy knows me too well. Ulele, so do you think there are any characteristics that are relevant to a practice at the Court of Protection Bar?
I pretty much endorse what everyone said. I mean, one thing, it's probably a different way of saying the same thing that Parishil said, but I would say that in the Court of Protection in particular, I think measure is important in the sense that, I certainly in other fields I've practiced in, there are situations in which a certain amount of controlled anger works. And I suppose that does in the Court of Protection sometimes, but I think that the style that's required much more often, to me, works better is when you kind of just take in what might be actually quite startling information and respond to it with calm. That doesn't always happen in other jurisdictions. And I think that that's something that I've learned from Court of Protection work, because you're always, as Parishil says, faced with all kinds of surprising things. And you can't go kicking and screaming every time somebody gets aroused. So you have to kind of be able to, modulate emotionally in a slightly different way than you might have to in other jurisdictions, I think.
Okay, 3 questions about qualifications. How much importance is given to GCSEs and A levels when applying for pupillages? And you know who I'm going to ask about this. Turan.
None. I mean, to be honest, no one looks at your GCSEs after university stage. Well, I don't think I had to put my GCSEs on my application form for pupillage. I think there is a section for A levels, but people don't really care all that much. It's more to do with how you've done at university, what you've done since then, and how you perform in interview. So I really wouldn't be too concerned about any anomalies in A level results.
Okay, what about not getting a first in your degree? Peggy, what would you say about that? does that mean you can't become a barrister?
I would say look at me, because I didn't get a first. So I got a 2-1. It definitely does not mean that you cannot become
You
a
were
barrister.
robbed, Peggy.
Pardon?
You were robbed.
I was robbed. I know, exactly. I was like, they didn't
You should
recognize
have got a first, but you were robbed of it. Is that your point?
a bit like the judges that I'm in front of. But no, you do not need a first. I'm very, very, very serious about that. It is competitive. And I think to get below a 2-1, you might struggle to get interviews. So I wouldn't, sometimes I give the advice, if people have got a 2 or below for a personal reason, illness, bereavement, whatever's happening in their life at that time, then it may be advantageous for them to perhaps do a master's and try and get a very solid result in that to effectively make up for it, so they can explain, because your intellectual ability, intellectual rigor is actually really important at the bar. So you need to be able to evidence that in some way. Another way of doing it is perhaps your academics are not that good, is to take a few years out, and in those 2, 3, 4 years, do something else that illustrates your academic or intellectual rigor. So example would be similar to one that Turan did about going off to the European Court of Justice, that type of thing. I spent about a year in JCWI, this is ages ago, Joint Council for Welfare of Immigrants, helping them with policy writing. So at the end of it, I had this policy or this report that I could say, look, this is what I've done. So there's other ways in which you can show your intellectual ability.
Ulele?
I mean, I think that's right, but I think some chambers, certainly mine, in the application process, we actually account for people who come from different kinds of backgrounds, etc. People who are returning to jobs or intellectual careers, and so there is there's a lot of space in our application for putting forward experience which you think counts, and
so what sort of things would that be, though?
Well, I mean, what we ask, I mean, it comes to Turan's point again, in a way. It comes to how you express yourself in a way, because we ask people, for example, to indicate what they've done that they think equips them for the bar. If they've had breaks in their educational progress, why are there those breaks, and how would they explain them, and how would they say that they can actually evidence some of the, if they feel that their academic qualifications aren't what they think is typical. And so how people answer that is often quite interesting, because you get people talking about being in a second career, you get people talking about not being disadvantaged socioeconomically and having to work. You know, for example, you get a clutch of people who've done a stage in Europe, who've done all sorts of things, when you know that they've been able to do that because in a way they've already been advantaged. And then there are other people who have to point to work they actually did, and then explain in relation to that they might not have been able to do voluntary work, but they say something about the paid work they did. And in a way, it's how they express that in the application form that might get them in the door, in our chambers anyway.
Can I just come in on that? I think Ulele's raised a really good point about other work. A lot of questions I've had from mentees that I've worked with have been, oh, but I had a job in Sainsbury's, or I stacked shelves in Waitrose. Is that really something I should mention? Absolutely, because the amount of client care that you have to dealing with very difficult customers in a supermarket is just the kind of thing you'd need when you're dealing with difficult clients who are harassing you on a daily basis through your emails and on the phone. So yes, I think the important thing is using something that you have done to show that you have a particular skill in that area. To give you an example, when I was doing my undergraduate and postgraduate education, I used to tutor part-time to raise kind of the extra cash that wasn't already covered by my scholarship. And I did that all day Saturday. I'd be tutoring, and I used that to show that I was able to crystallize and summarize things for people who clearly required the help and required my input to understand. And that's exactly what you'd be doing as a barrister, aiming to make clear, concise submissions to a judge to explain that case. So what's important is the way you use that information to show what you're trying to achieve.
Right. Thank you very much. Right, one final question. Would you recommend master's degrees, Parishil?
I would recommend as many years of not working before you start working as possible. So yes.
But because you don't like working or some other reason?
No, because you're going to spend most of your life working. So it's best to do lots of things before you come to, especially at the bar. The bar is all encompassing. It's you know, it's absolutely rewarding, but we all work very, very hard. And at times, especially this year, I think in where we've all been lucky enough to continue our practices and be busy. But I feel like I don't know where the year's gone, to be honest, but I remember, well, I mean, it was probably not as long ago as you, Vikram, but I do remember back in the student days that I just enjoyed. Yeah, I don't remember it. And just spend as long as you can not work, you know, sort of doing other things, doing masters, going traveling, doing interesting other kind of volunteer jobs or non-volunteer jobs, whatever you can do, to be honest, before you come to the bar, because the life experience you get will really help you when it comes to being a barrister.
I think I tried to answer this, but I perhaps was unsuccessful. Perhaps I needed a master's to answer the Q&A function. But
maybe you should do one now. Yes.
Yeah. But I think masters are useful. Well, certainly, I'm speaking only about the application process in my chambers. I don't know whether, but I know it's so for lots of others. Is that, for example, in terms of, so we have a huge range of categories, and obviously academic ability is one of them, and it's marked quite it's marked quite highly. So if you've got a master's in my chambers, that counts for more than just the first degree. So in a competitive environment, having a master's as a way of entering the profession, I would say, is quite useful. But it's not the answer. But if you've got it, it helps. And on another level, you know, doing a master's can actually refine certain intellectual and analytical skills. So to that extent, it might be helpful. But what Parishil says is also true.
Right. Well, I think those are all the questions we've got time to answer. Thank you very much for listening to us. I hope you found it useful, and thank you very much indeed to the panelists for giving up your time on Friday evening. Now, if there weren't certain laws in place, you could now go to the pub, but unfortunately you're just going to have to stay at home. But I hope you have a very nice evening, everyone, and thank you very much. Bye-bye.
Thanks, Vikram.
Thank you.
Bye.
Everyone.